Be ready. Start. Under Section 226 of the Code, while opening the case for the prosecution, the prosecutor has got to describe the charge against the accused and state by what evidence he proposes to prove the guilt of the accused. Thereafter comes at the initial stage the duty of the court to consider the record of the case and the documents submitted therewith, and to hear the submissions of the accused and the prosecution in that behalf. The judge has to pass thereafter an order either under Section 227 or Section 228 of the Code. If the judge considers that there is no sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for so doing as enjoined by Section 227. If, on the other hand, the judge is of opinion that there is ground for presuming that the accused has committed an offense which is exclusively triable by the court, he shall frame in writing a charge against the accused as provided in Section 228. Reading the two provisions together in juxtaposition as they have got to be, it would be clear that at the beginning and the initial stage of the trial, the truth, veracity, and effect of the evidence which the prosecutor proposes to adduce are not to be meticulously judged, nor is any weight to be attached to the probable defense of the accused. It is not obligatory for the judge at that stage of the trial to consider in any detail and weigh in a sensitive balance whether the facts, if proved, would be incompatible with the innocence of the accused or not. The standard of test and judgment which is to be finally applied before recording a finding regarding the guilt or otherwise of the accused is not exactly to be applied at the stage of deciding the matter under Section 227 or Section 228 of the Code. At that stage, the court is not to see whether there is sufficient ground for conviction of the accused or whether the trial is sure to end in his conviction. Strong suspicion against the accused, if the matter remains in the region of suspicion, cannot take the place of proof of his guilt at the conclusion of the trial. But at the initial stage, if there is a strong suspicion which leads the court to think that there is ground for presuming that the accused has committed an offense, then it is not open to the court to say that there is no sufficient ground for proceeding against the accused. The presumption of the guilt of the accused, which is to be drawn at the initial stage, is not the sense of the law governing the trial of criminal cases in France, where the accused is presumed to be guilty unless the contrary is proved, but it is only for the purpose of deciding prima facie whether the court should proceed with the trial or not. In the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it is challenged in cross examination or rebutted by the defense evidence, if any cannot show that the accused committed the offense, then there will be no sufficient ground for proceeding with the trial. an exhaustive list of the circumstances to indicate as to what will lead to one conclusion or the other is neither possible nor advisable. We may just illustrate the difference of the law by one more example. If the scales of Pan as to the guilt or innocence of the accused are something like even at the conclusion of the trial, then on the theory of benefit of doubt, the case is to end in his acquittal. But if, on the other hand, it is so at the initial stage of making an order under Section 227 or Section 228, then in such a situation, ordinarily and generally, the order which will have to be made will be one under Section 228 and not under Section 227. If two views are possible and one of them gives rise to suspicion only, as distinguished from grave suspicion, the trial judge will be empowered to discharge the accused, and at this stage he is not to see whether the trial will end in conviction or acquittal. Further, the words not sufficient ground for proceeding against the accused clearly show that the judge is not a mere post office to frame the charge at the behest of the prosecution, but has to exercise his judicial mind to the facts of the case in order to determine whether a case for trial has been made out by the prosecution. In assessing this fact, it is not necessary for the court to enter into the pros and cons of the matter or into a weighing and balancing of evidence and probabilities, which is really the function of the court after the trial starts. Thank you.